Hello, I'm Avi Lewis. Welcome to Counterspin. Tonight, Immigration Minister Elinor Caplan joins us to debate her biggest policy contribution, her legacy of legislation, Canada's new immigration law. Bill C-11 is likely to be passed before the House breaks in June, but the fast track runs right through a forest of objections. The most explosive criticism of the new law is that it will allow permanent residents to be deported without appeal if they're convicted of a crime in Canada and sentenced to at least 2 years in jail. So someone who arrived here as a toddler, who has lived, paid taxes, and raised a family here, could be shipped back to the country where they were born for a crime like car theft, or passing oneself off as another, like on a radio call-in show, or forgery, like faking marks at a law school. That measure has drawn fire from a rainbow coalition of critics, including the Canadian Bar Association, Amnesty International, the Canadian Chamber of Commerce, did I get that right? Even the Liberal chair of the Immigration Committee himself, MP Joe Fontana. But it's not the only controversy. Critics also say the new law gives sweeping new powers to immigration officials, leaves too many important details to undebatable regulations, and strips away other crucial legal safeguards from all potential immigrants and refugees. The government, on the other hand, insists that the legislation does not compromise civil rights, but merely cracks down on people smugglers and criminals while making sure that we attract the best and brightest immigrants. See, I can do the government line too. Since we are thrilled to have the minister here and we applaud her instinct to be accountable to the public, the first segment of the show will be a one-on-one encounter between the minister and one of her critics. Then we'll open up the rest of our time to the audience, which tonight is filled with experts in the field. So I'm pleased to say that joining me at the table is Elinor Caplan, Federal Minister of Citizenship and Immigration. Welcome, Elinor.
Welcome. Nice to see you, Avi.
Also here tonight is Rocco Galati, former Crown Counsel in the Department of Justice, now an immigration lawyer. Hello, Rocco.
Hi, Abby.
All right, so the challenge of new legislation is to balance Canada's, our self-image, our immigration tradition of compassionate country building with the new hype around people smuggling and international terrorism. A lot of people, Elinor, I think that you have got that balance totally wrong. So tell me how you got it right.
Well, I think the legislation is balanced. The mandate of my department is to bring the people here that we need to help build this country. Canada is a country that was built by immigration, immigrants and refugees who come with the same hopes and dreams over generations. But everyone, I think, has lost patience with how long it takes for us to remove criminals. And so we're streamlining this legislation. First time in 25 years that we've seen new legislation. Previous legislation was before the Charter of Rights and Freedoms. And we know that things take too long. So we streamlined our refugee determination system in this legislation so that people can get on with their lives in Canada more quickly, and if they're not eligible to stay because they don't need our protection, they'll be able to get on with their lives outside Canada more quickly.
That's a nice way of putting it.
And for those people who are not admissible to Canada, who are criminals, or those who come to Canada and commit a crime, we'll be able to remove them more quickly. The goal here, and I've said it before, is to close the back door to those who would criminally abuse, so we can open the front door wider. Last year, I was proud that we met our levels. We need people, but we also have to restore the confidence of Canadians that we are able to take action more quickly when there is someone here who is a criminal or is abusing and not respecting our laws.
Rocco, what do you make of the balance?
Well, there's no balance. This is taking a sledgehammer to a centipede. The legislation is lean, mean, nasty, and unforgiving. The measures were there to address the concerns that Elinor speaks of about getting rid of these so-called coyotes and smugglers. If there was any hesitation, it was because it was not properly enforced and the resources were not there. The laws were always there. This thing about this wholesale amendment, that's nonsense. The Immigration Act has been wholesale amended every 4 years. There was one in 97, 92, all the way back to 76 and 52 and 53. What's happening with this legislation is it might as well be called the criminalization of the Immigrant Act, because that's what it does. It takes this tribal emotional reaction to a few isolated incidents in the country and says, let's deal with these criminals. Well, we've always had the effective means to deal with criminals.
I think we see there's a spectrum of debate here, and this is, Rocco is echoing a lot of the criticism that you've heard on the bill. So let's talk about the specifics so that we don't get entirely rhetorical. The most controversial measure is the question of deporting permanent residents.
No. Deporting permanent residents who have committed a serious crime in Canada.
Right.
So it's the ability to deport a criminal.
Right. Okay. Well, you want to relabel them criminals. Let me just read you a quote from Joe Fontana, who is your caucus colleague and chair of the Immigration Committee. he was quoted in the newspaper saying, well, it's important to make sure that we are safe and secure and we don't let criminals in. We don't want to make the bill so responsive to that kind of mentality or myth that we are prepared to remove rights from people who are here and want to be good citizens. So what is the justification for this measure? It's a new measure, the ability to deport permanent residents.
I think Joe's point about wanting to welcome law-abiding citizens is right on. Most Canadians are happy to welcome those who want to come and obey our laws. But if someone comes here and they are not a Canadian citizen and they commit a serious crime, punishable by up to 10 years, where a sentence of at least 2 years has been given, I believe Canadians want us to be able to remove that person faster.
That person who may have been living here since childhood.
That person who is not a Canadian citizen and is not entitled to remain in this country because they're not a citizen. If you do not have citizenship in this country, you can be deported if you commit a serious crime. And I think we have to be able to do that more quickly than we do today. It takes us years to deport serious criminals who pose a risk to Canadian society.
Well, let's bring that down to earth. It doesn't take years to deport serious criminals. Nobody has any objection to deporting serious criminals when they've committed crimes here, and we've given them a process for deporting them. It's how you deport them and the mechanisms you choose to deport them. Let's bring this down to earth. Under the new legislation, 2 years is not difficult to get a sentence on. So your 40-year-old grandfather from Ukraine or Italy or Portugal who has a drunk driving accident and who gets convicted and has a suspended sentence, first and only and last time, all of a sudden gets whizzed out of the country in an unforgiving way. A 2-year sentence for criminal negligence causing bodily harm in an auto accident, for instance, is not unheard of. So it's how and who determines whether or not they're criminals. What you've done in this legislation is you've said Parliament's irrelevant. We decide which criminal. The cabinet, the minister in the closet of her ministry decides what's criminal. The officers, immigration officers, then decide who's inadmissible. There is no effective judicial review of that. You've cut out the courts because they overturn about 67% of the cases that get to the court as being unfair and unfounded in law. The courts are no longer around. So what you've done is said, look, let's do it the way we do it in Guatemala. Give the officer with the badge, with the grade 12 education, all the power to determine who and when and where a permanent resident is going to be deported. Nobody disagrees with you.
That is a gross misrepresentation. First of all, every decision, every administrative decision by an immigration officer or by the government is subject to judicial review. What that means is federal court oversight. So to suggest that there isn't effective review by the federal court is just wrong.
So that means that people can appeal? People can't appeal.
No, they cannot appeal.
Judicial review,
no.
The federal court oversight is there, and the justice lawyers say that everything that is in this legislation meets the test of our Charter of Rights and Freedoms. So we are protecting the rights of citizens and permanent residents. They have an opportunity.
Okay, but I'm not a lawyer. Do you get an appeal or no?
No, you don't.
What you do is you have oversight by the federal court. You get an opportunity to have your say, but it is not, it's the legislation that sets out what are the terms and conditions. And for example, just a minute, let me finish.
All right.
Where you say it's in the closet, it's not. It's clear. We've said a crime punishable by up to 10 years where a sentence of at least 2 years has been given. That means at that point, it's clear, you've had your day in court. The courts have said, you're guilty of a serious crime.
Well,
that's
you'd be
a
guilty
serious
of that
crime in
if you
Canada.
used your friend's library card at U of T. That's personation, an indictable offense. You could be guilty of that. I mean, is that serious? Now, with respect to the judicial review, there is no judicial review. You can ask permission of the federal court to look at the case.
That's right.
Of all the thousands of cases that are filed for permission, 2% get permission from the court. Now, of those 2%, let me finish now. Of those 2% that get to court, a good 60-odd% are overturned. What's that tell you? That the people who actually get in court have been done an injustice. But you know what? The federal court doesn't have time to look at every decision. So you get a butchery of injustices done to those people who can't get into the court.
The federal court has the opportunity to review every one of the cases that are brought to them, and they can weed out the ones where they believe they are frivolous and review those where they think that people have not been treated fairly. The goal of this legislation is to do things faster, but ensure that we are fair. And everything that we're doing meets the test of the Charter of Rights and Freedoms, and I don't think Canadians
Well, it hasn't been tested in court. It hasn't been tested in court.
This is the advice we have from Justice.
Right.
And my view is that Canadians are impatient with our inability to remove serious criminals from Canada quickly enough.
Given
all the steps that are in place now and all the possibilities for judicial review, I'm with the majority of Canadians who say we have got to be able to do things faster. We spend too much time saying no and too many resources saying no. We have to be able to reallocate those resources so we can say yes to the people who want to come and be law-abiding and help us build this country.
Let me keep moving here, because there's a lot in this legislation, and we're not going to get to all of the topics. But on the topic of permanent residence, let's move away from the deportation and talk a little bit about compelled examinations. What's a compelled examination?
Well, first of all, before anybody can be arrested, they have to have a warrant. And before you can ask anybody to come in and give information, you have to have reasonable grounds to believe that they are inadmissible to Canada. So there's a high legal bar.
So what's a compelled examination?
What it means is come on in, talk to us, because we think you may be a terrorist. We think you may have committed a crime and be inadmissible to Canada. We think that, and we have evidence to suggest that you have a problem with immigration.
Okay, well,
so we invite someone to come in, to have an interview, and to discuss these facts. Now,
it's not an invitation if it's compelled.
It's not an interview because...
No, just a minute, it is. Because if we have evidence and that we arrest, then there's a warrant. If not, you come in where we have reasonable grounds to believe that, and that's evidence.
Let me just... I'm sorry, I got to get in here. No, listen. An immigration officer, again, let's bring all this stuff down to earth, because I don't deal in the cyberspace of rhetoric. I deal with real people every day. And some guy on College Street who doesn't speak any English is walking around. An immigration officer says, I think you're admissible, come with me. He brings him down to the office. If he refuses to produce documents or answer questions on that compelled examination, he can be issued a removal order on the spot. And if he refuses to answer questions, it's punishable by a fine of I can't remember how many tens of thousands of dollars and 2 years in jail. So the fact that he refuses to comply without the assistance and right to counsel, he's going to be deported.
Well, as a matter of fact, what's important for people to know is that anyone can have counsel with them, that they are entitled to judicial review of any decision that is made by an immigration officer, including a deportation order, and that before they can bring you in for an examination, they have to have reasonable grounds to believe that person is in the court's oversight.
No,
the federal court oversight is there to make sure that the officer.
So the officer has to go to court and justify why they want to compel someone to be examined.
In Canada today, immigration officers have those authorities to bring people in if they have concerns that they are not eligible to stay in Canada. And every decision is reviewable by the federal court. That's the way this country works. We have a Charter of Rights and Freedoms, and if we believe that that charter is being offended, then lawyers take us to court.
No, listen. That is not the way the legislation reads. You should have the justice lawyers read it to you again, because at the border, right now, immigration officers can ask questions to people trying to get in. If you're already here, a permanent resident, you can't be hauled off the street without, at will and at the whim of any immigrant.
It's not at whim, it's where they have reasonable grounds to believe. That's a high legal test.
No, it's not. And furthermore, the immigration officer can pull a permanent resident off the street. He's been here 30, 40 years. And that permanent resident, if he doesn't comply with everything the officer wants, is then removable. That is unheard of in our legal system, that you can be hauled off the street. Police officers don't have that power, for God's sake.
Listen, just a minute. Okay. You are talking about people that we believe may be terrorists, have criminal records.
Elinor, it's a question of process.
It is a question of process.
And the process is changing.
And the immigration
process is changing, right?
The immigration officers have to have the authority, I believe, within the context of our Charter of Rights and Freedoms, to do their job, which is to protect Canada's national security. People want to be able to know that if people are abusing, if criminals are coming into this country,
you know very well,
if they are a threat
to national
then
security,
we have to be able to take action.
You have those wonderful CSIS provisions, of which I'm the only lawyer to beat one last year, where you have the most draconian in-camera process where we don't even get to see the evidence. If somebody is a threat to national security, you know very well right now there's a CESA certificate issued, and then the person is put in chains, maximum security, no bail, and we go in front of a federal court judge, and we don't see the evidence. The lawyer is blindfolded, the client is blindfolded. So don't tell the viewers that this only applies to people walking the streets who are a risk to national security, because if they are a risk to national security, you would be invoking the CESA's provisions.
It applies
to just any permanent resident.
That's not true.
Yes,
we are talking about people where immigration has evidence and reasonable grounds to believe that they may be a war criminal, a terrorist,
or medically
someone who has committed a serious crime, someone who has committed fraud and misrepresentation.
Or medically inadmissible, right?
What I think
or medically inadmissible, ill?
One of the things
yes or
that
no?
we have
yes
said...
or no? If they're ill and they're inadmissible, aren't they subject to the same process of being hauled off the street, yes or no?
The answer to your question is the intent of this legislation
yes or no?
is to protect Canada from those who are serious
somebody's in a
criminals.
wheelchair, they're going to be hauled off.
Absolutely
you know, now that people are talking at the same time,
ridiculous.
Elinor, before this descends to question period level, let me just take a commercial. We have a large audience who is already shifting in their seats, and we'll bring them in when we come back. Don't go away. Parliamentary propriety here, please.
I thought I'd make her feel it.
Closed captioning of this program is brought to you by Grand Marnier. In a margarita, in a Cosmopolitan, on ice. Consider Grand Marnier. It changes everything.
Imagine escaping away from it all. Now you can with the Best of Solitudes, the 20th Anniversary Collection. Featuring over 2 hours of music and pristine nature sounds, the Solitudes collection provides the ideal escape. Also receive a soothingly intimate wave-watching video and experience the unique journey of pure sound and visual ecstasy. Call the toll-free number now and secure the ultimate experience of sight and sound. You will receive the Best of Solitudes, 2 CDs, and the wave-watching video for only $24.95 plus $5.95 for shipping and handling. Have your credit card ready and call now. Relax with the Best of Solitudes, the 20th Anniversary Collection, and wave-watching video.
The 20th century was one of widespread progress and invention, except when it came to cleaning the floors. But that all changed with Swiffer WetJet. Push the button. WetJet dissolves and absorbs dirt, cleaning places you never imagined you could before. And when the job's done, so's the dirt. Swiffer WetJet, cleaning the 21st century way.
Henry had arthritis pain 8 hours ago. For Henry's arthritis pain, it works. He's one of over 16 million Canadians that trust the name Tylenol for pain relief.
Simply the best classical anthems CD. "38 of the most powerful classical anthems on earth. Every listen will make you feel incredible. Simply the best classical anthem. Pick up this specially priced 2 CD set in stores now."
We'd like to show you our underwear. Not that you can see it. Introducing Tenna Protective Underwear for bladder control problems. The discreet maximum protection pant that pulls on and off like underwear. Who says the obvious choice has to be obvious? Tenna Protective Underwear. For a free sample, call 1-866-GET-TENNA. A breakthrough in dignity.
We're back on Counterspin. We have the Immigration Minister here to talk about Bill C-11, which is the new immigration law. It'll probably be law, by the summertime. And I want to move on. We've been talking about permanent residents and their change in the regulations and procedures that apply to permanent residents, which are new. Another new thing regarding permanent residents is the relationship between permanent residence cards, which you have to renew every 5 years, and the residency requirement. You have to live in Canada for 2 years out of those 5. Okay, so we've got new cards and new residency requirements, and I've read a lot of criticism about it. What is the problem with the
Well, what we
with the new
basically
system?
are going to have is that there will be a card which will be provided to a permanent resident, which will be valid for 5 years, and that person would show that card to the airline and be permitted to come into Canada.
Right, if they go to a visit in another country or they study abroad. Or, okay.
But the problem that I see is that when a person has been outside of Canada for an extended amount of time, and the government, to their credit, has expanded the flexibility, permitting permanent residents to be abroad longer, but if you are away too long according to the government standards, then the problem is that you have an appeal, but that appeal right to be in Canada is based on your nationality. So for example, if you are a permanent resident of the United States, you can come into Canada and appear before the Immigration Appeal Board and argue your case. But if you're a permanent resident, for example, of China, India, you can't come in. So I would ask the question, why are we basing this right to appear before a tribunal on your nationality? I would say it would violate the Charter.
Elinor.
Well, in fact, we're talking about all permanent residents who have the opportunity for an oral appeal. This legislation makes it more flexible, 2 years out of 5 instead of now it's if you're away for more than 6 months.
Right.
What we're putting in place is a system which is fraud resistant. The card will replace the permanent resident papers right now, which we know are open to all kinds of fraud and concern. And it's in the public interest, I think, to have a better system to do this. But what we've said is that anyone who has been out of Canada for less than a year, no matter where they're from, will be given a facilitation visa so that they can come into Canada. Anyone who's been away for more than a year has obviously established themselves outside of Canada, and they will have access to an oral hearing via telephone or via teleconference. But we have countries where we have visitor visa requirements.
So if you happen to be coming from a country that you need a visa to get into Canada, then you can't get here for your
But those
hearing.
laws apply right now, and they are reasonable in the context of Canadian immigration policy.
Go
The
ahead.
concern here is to make sure that anyone who comes to Canada has a right to be here, and that if they don't have a right to be here, that it doesn't cost Canadian taxpayers a fortune to remove them.
I agree that visitor visas, we provide that to various countries. Some have visas, some don't.
Right.
But the problem is here, we're talking about permanent residents. And a permanent resident, if you're from China, you're from the United States, should have the same rights. And this legislation is not doing that. You have an advantage to being an American citizen because you don't need a visa to come to Canada. But if you're from China, you can't come here and appear before this board. So there is a discrepancy.
Well, you can appear before the board now. There's no right to re-enter Canada now unless you can convince an immigration officer at a port of entry that you have a legitimate
That's
reason
not
to be
true.
in Canada.
That's
There's
not
no
so.
guaranteed
I'm sorry,
right in the
Elinor.
existing legislation.
I'd rehire new justice lawyers. That's not the case.
Well, it is the case.
It is not the case.
And under the new legislation, I think it's more flexible because it guarantees everyone a right who's been away for less than 1 year. If they have a card that's expired, they all have the right to enter.
Under the current law, a permanent resident is presumed to be a resident until the bodies to adjudicate that have adjudicated that, and they have a right to re-enter Canada for that
That's not true.
purpose. Yes,
No,
it is.
that's not true.
Yes, it is. Yes,
There's
it is.
no guaranteed right in the legislation
there
for
is.
anyone to enter
Why are you
Canada.
shaking your head?
Because in this instance, Rocco is, I believe, quite correct. The Immigration Act stipulates that a permanent resident has the right to enter Canada. If one is challenged at the port of entry, one is here having that challenge determined by our appropriate system. If one is not permitted the opportunity to get here for the purpose of having it determined, there's a definite disadvantage. If one is a citizen of a visa requirement country, one is, as Stephen said earlier, at a distinct disadvantage.
I know you wanted to jump in here. Go ahead.
Actually, I wanted to jump in on the issue of deportations. I think, Elinor, you're aware of the Jamaican Canadian Association's position on deportation. What we are saying, essentially, is in many of the cases, what you're deporting is a Canadian who has not gone through the paperwork. You're sending people back to countries that don't have the resources to deal with them. We want this provision out of the legislation. We believe that people who are here and who are convicted of crime and who have come through a process of being conditioned of growing up in this society, which in many ways is very racist and which is one of the contributing factors, for people who commit crime, that we should deal with them here. get them the resources here for rehabilitation and for transition back into, into law-abiding livelihood.
I understand your position. Let me tell you something. As Minister of Citizenship and Immigration, my job is to consider what is in the public interest of Canada. I understand that lawyers have interests of their clients and that associations have other interests. The interests of the government of Canada is what is in the public interest. And if someone is not a citizen of Canada and they have committed a serious crime, we have the ability under the law to deport them. We want to be able to deport them as quickly as possible. We think that's in the public interest.
Before you fall off your chair, I'll be with you in a second.
I was just going to add a comment. I don't think it's in the spirit of most Canadians to say that a person who spent their whole life in Canada and has no family necessarily back in their home countries, have been here since they're since a child. I don't think Canadians are mean-spirited as you think. I don't think the average person on the street would say, remove that person without any possibility of review. We're not saying that they automatically get to stay in Canada.
Well, there is review. There is review.
I'll get to your what you consider review, because I deal with the federal court and I know the standards that apply there. But what we're saying is...
So don't say there's no review, because there is review.
Under the new legislation, there will be no review to the Immigration Appeal Division. And if there is review at the leave stage, if they make an application to the federal court, they're already removed from the country. There's no automatic right to stay in the country. And it's procedural, it's not substantive, it's based on whether there's been reviewable errors. It's a very, very high standard, and you know that only about 2 or 5% of the cases get through. I'm talking about someone who spent their whole life in Canada. They are, as that woman said, a product of Canadian society. I don't think if you took the average person on the street and said, should we throw them out of this country without a proper and fair review to review the whole circumstance of their case, they would agree with you.
Well, in fact, I would argue that there is a proper and fair review, and that Canadians are frustrated because we don't want to have to keep people who have committed serious crimes, murderers, serial rapists, and those who have committed serious crimes in Canada who pose a danger to Canadian society. People want them out of here. And I think we should be able to remove them as quickly as possible.
Minister,
it's just taking too long.
But Elinor, what are we sending them back to? And I brought this today because this is a good example that showed up in yesterday's Toronto Star, the O'Neill Grant case, where after being half of his life here in Canada, there is an attempt to deport him. He gets to stay. He is acquitted in the Just Desserts case. And because of non-criminal activities while being held in jail, you're now looking to try and deport him. What are you deporting him back to? Isn't he a product of Canadian society? I think that's the crux of the argument.
She's going to say that she can't comment on
I will not comment on
I know you will not, but
on the principle,
just to have a good example that somebody who came in at age 12, at age 22 is being deported back to what? And isn't the fact that he grew up here and his teenage years were here means that it is a Canadian problem?
I think Canadians fundamentally disagree with you. I think they believe that if someone is not a Canadian citizen and they pose a threat to Canadian society... But
how do you know when you walk down the street who's a Canadian... How do you know when you walk down the street who's a Canadian citizen and who isn't?
I believe
my neighbor, I have no idea.
want us to be able to deport serious criminals if we can.
Where were you born, though?
I was born here in Toronto.
I have no way of knowing that. What if you came here when you were 18 months old? Mm-hmm. This is a technical distinction. This is paperwork.
I disagree, Avi. I believe that it's in the public interest in Canada not to grant the right to stay to people who are not citizens. No, but we can extradite citizens if they commit crimes in other countries. We can deport people who are not Canadian citizens who are presently in Canada. And I believe it's in the public interest to be able to do that and to do it more quickly, so we'll have the resources to bring the people here that we need more quickly.
Go ahead.
I think we're running around in circles here, and I think...
You noticed that?
Yeah. Okay. No, well, I'm not a lawyer, but I want to speak of some of the other issues that are included in this bill.
Okay.
I mean, there's a lot of progressive measures. You know, first of all, we include international agreements such as the Convention Against Torture. We talk about the rights of the child. These are new rights given to people wanting to come to Canada. These are included for the first time in this act. There are other measures. I'll give you a personal example. I have a friend who's an American student. She wants to come and immigrate and become a landed immigrant in Canada and become a Canadian citizen. And she can do that under this new act. There are new regulations involved for foreign students where they can come here and become a Canadian citizen easier. And I think these are the type of measures that we should be talking about as well, because this bill is very, very progressive in this sense.
And of course, that's the balance of the legislation.
Let me grab that moment just to say, we got to breathe, everyone breathe. 2 minutes, we'll be back. Time is flying tonight. What were you
I'd
saying?
like to respond to that when I come back on that very issue.
Welcome to Panama.
Critics declared the Tailor of Panama is a mind-blowing spy chase. Pierce Brosnan. Gotcha. Academy Award winner Jeffrey Rush.
1 out.
The Tailor of Panama starts Friday in select cities.
Bates.
Right.
Bates.
Right.
Bates.
Right.
Bates.
Right.
Bates.
Right.
Bates.
Some things are meant to be
baked and paid.
And we think pizza's one of them. That's why McCain Pizza Pockets are baked like pizza.
Right. No.
So you get all that baked pizza taste. McCain Pizza Pockets taste better baked than fried.
Baked.
News that is comprehensive. Coverage that is incisive. Analysis that is thorough. Saturday Report with Mark Kelly. Good evening on CBC Newsworld.
You know, when I first came to Canada a few years ago, my accountant advised me that I needed a Canadian legal will. We were going over all the financial aspects of my estate, and the only thing that wasn't in order was my will.
If you have assets in this country, you need a legal will. Gail is divorced, a mother of 3. She travels and she has a company. If she wants to make sure that her estate is left to the people she cares about, it's her responsibility to write a will.
The Canadian Legal Will Kit gave me the flexibility I needed. I simply followed the instructions to make a will that's legal in all provinces. It doesn't matter what your circumstances are. The Canadian Legal Will Kit will give you all the information and the flexibility that you need to make sure that your family is secure.
If you're serious about handling your own finances, ensure that you have a legal and updated will. Order your Canadian Legal Will Kit today. It's only $29.95.
Order yours today.
We're back on Counterspin. We're debating a new immigration legislation, and you've been waiting patiently.
Well, actually, I don't work in the immigration system. I don't understand a lot of it, but I'm one of the people who spent years saying we need more in the tool chest in the fight against transnational crime or insurgency. And there are a lot of things here that I think make sense. On the other hand, there's some things that are more draconian than anything I wanted.
So it's like you're saying there's stuff that's more draconian?
A bit.
I'm blown away by that.
But one of my real concerns is that, for example, the political process where the minister or her delegates start the whole thing about the security certification. Sorry, we have a country that is sometimes very selective in who it goes after. And, for example, transnational crime, one of their characteristics is they seek out political engagement. We have organized crime groups in Canada that have got very heavily involved, especially with, governing political parties. Same time with some insurgent groups, one of their characteristics is they try and dominate cultural expression inside small communities.
So what's your point?
I don't think the regulations will be even-handed. I think some groups are going to get off a lot more lightly than other groups.
Do you want to speak to that? Oh, you're passing the buck to your friend.
Well, I think I don't really want to talk about the business of transnational crime. I don't think Canada has huge problems in this.
We've had debates about how much of a problem it is. The minister is convinced that it's worth a big piece of the legislation.
I think that there are so many things that to be concerned about, and Rocco has actually mentioned a number of them. But just to get back to one point, and that is the appeal, because the minister keeps saying there's a judicial review, and there isn't a judicial review of the situation of a person who is automatically deported without an appeal. What are you going to do? You're going to judicially review whether or not the section of the act is the section of the act that he was convicted of? There's no appeal in that way. So there's absolutely no review, and there's no consideration of not only the fact that the person has lived in Canada, but the fact that this person has family, has perhaps has children, perhaps has completely rehabilitated since his incident of crime. We believe in Canada not in retribution in our justice system, we believe in rehabilitation.
But I have to cut in there, Avi. You know, everybody's corralled this debate about criminals. This act applies to all aspects of immigration. And this gentleman here earlier spoke about, we recognize the rights of the child. Well, me and Mr. Roger Rowe had to go to the Supreme Court of Canada to recognize the rights of the child. In the Baker decision, a woman who'd never committed any offenses, 4 children born here, 2 of them in high school, Canadian citizens, a productive member of this society from Jamaica, and they still wanted her out. We had to go to the Supreme Court. Her ministry would not recognize that the rights of her children should have been considered on a humanitarian application.
Well,
the court had to order her ministry to do that. So we're not talking just about criminals. Let's get away from this boogeyman, straw man criminals.
Just a minute. This legislation does enshrine the rights of the child as a consideration. I think there's many progressive things that balances the need of Canadian society. I think it's good legislation because it does do many of the progressive things that we've talked about to allow us to bring people here more quickly, but it also allows us to streamline procedures to remove those who are the bad guys and gals. There's no question about it. That's our intent.
Or who are medically sick.
This legislation actually causes discrimination, and it impacts the poor and disadvantaged, and also it separates families, displaces them. For instance, if a family who has no country to return to, for example, a Somalia, which has no government at all, where are you going to return them? You know, and then I think the justice system can deal this. There is a justice system that can rehabilitate, punish the criminals, and there's already a system there, justice system still. We don't need a legislation to be implemented into which discriminates people and bases on their nationality, and discriminates in the basis of where they come from.
Well, in fact, it doesn't discriminate on the basis of nationality. What it does is it treats everyone equally, but it's important for everyone to know that faster family reunification is a cornerstone of the policy. It allows refugee applications to keep their application open
faster
for a year.
reunification and faster separation. That's balance.
Faster deportation of those people who have committed serious crimes in Canada or those who have committed crimes outside Canada and are criminally inadmissible. This bill is tough on criminals and those who abuse and do not respect our laws.
Go ahead.
This bill is tough on permanent residents. Your suggestion that the standard for compelled examination is a high one is intriguing to me, because yesterday I got a letter from a client of mine, and the letter was opened by Customs, and actually all it was just a check paying my fee happily. And what happened...
I got an open package too recently.
Well, there you go.
It was a video from the Cuban ambassador.
I'm not going there. So the test for intercepting the mail of Canadian citizens like me is they have to have reasonable grounds to believe that the contents of the package are involved in some criminal offense. Well, you know, I work at a corporate firm. I've never had any trouble in my legal career. There's no reasonable grounds for opening something. Even that search violated what the Privacy Commissioner said the search should be like last week. But the important point is it's the same test as the test that your people are going to apply when they decide to do an arrest. So if you randomly open the mail, which your spokespeople already admitted that you do, your ministers admitted that you do because you think it's in the public interest, then I want to know how immigrants are going to be protected from searches that are conducted on maybe, just somebody from next door, having trouble with a neighbor and then making a report to the department, and all of a sudden they've got to come in. And
what he has said is completely inaccurate. My department does not open the mail, and there has to be reasonable grounds before we are able to seize mail. So it's important to know that Revenue Canada has the authority to open mail when they are concerned, and the Privacy Commissioner reviewed that and said that they do it in a lawful and appropriate way.
The test is on reasonable grounds.
Reasonable grounds is for being able to seize mail with my department.
Reasonable grounds is being able to open mail. That's what the customs legislation says. They can't open my mail unless they have reasonable grounds, and they do. They say random. Well,
they have the authority under the legislation where they have
hold on, let's stay focused on the new immigration legislation.
Immigration does not do that. I met with the Privacy Commissioner to discuss that very fact with him, and our concern is that we know that there are fraudulent documentations, fraudulent passports, all kinds of fraudulent documentation, which is feeding smuggling of people and trafficking in humans.
So on that grounds, we randomly search the mail of Canadians. That's exactly what Canada's all about. I'll tell you something else. You're giving immigration officers the right to force people to incriminate themselves, and if they fail to do so, they can be removable from Canada. The police can't even have that power when they're dealing with a murderer, but your immigration officers are going to have that power to deal with a simple immigrant. Is that wrong too?
The intent of this legislation is for immigration officers, where they have reasonable grounds to believe, if they want to arrest someone, they have to have a warrant, and if they want to question someone, they have to have evidence, and all of that is subject to review by the federal court.
Listen, forgive me, but I have reasonable grounds for going to a commercial, otherwise we're going to get in trouble here. We'll be back in 2 minutes. I'm here.
Got a legal problem? Call Becker Mathers.
A drunk ran a red light. The victim's car was thrown 78 feet. He was pinned beneath the dash. It took them an hour to get him out of there. If you were the victim of an accident, who would you call for legal help?
Call Becker Mathers. We'll fight for you to make the guilty party pay for your pain and suffering.
The law says you can wait only so long, so call now.
Got a legal problem? Call Becker Mathers now. 438-8234.
You are about to experience the unsurpassed beauty of the world's most glorious music. Introducing Opera's Golden Moments, a magnificent new collection featuring 40 of the most popular songs from opera. Here are some of the best-loved songs of all time. Even if you don't understand the language, the songs project magical images and powerful emotions. These are pieces so popular, many of them have been featured in movies and television. You'll enjoy brilliant performances by the biggest names and greatest voices of opera. Almost 3 hours of the most well-known arias, duets, and choruses. Songs that touch the heart. Immerse yourself in feelings of warmth and serenity. So many of the world's most beloved artists. Opera's Golden Moments is not sold in stores. You can only order it through this special offer. Here's how to order. Call this toll-free number now for Opera's Golden Moments. 3 cassettes, $24.98. 3 CDs, $29.98. Plus $4.95 shipping. Have your credit card ready and call now.
They may never meet, but their destinies are linked. She knows her research saves lives. So does she.
We're back on Counterspin with just a couple of minutes left to talk about new immigration legislation.
Honorable Minister, I work as a frontline worker with the Canadian Center for Victims of Torture. We protect victims of torture. They shed bitter tears before us and we cry with them. I have an appeal to you. I beg you, I request you to incorporate Article 3 of the Convention Against Torture in its full dimension in the new Immigration Act. There is a case before Supreme Court of Canada. You will lose nothing if you withdraw the case and send an explicit message to the whole world that Canada, under no condition, would send any human person back to torture.
You want to make a commitment right now, Elinor?
What I can tell you is that I can't comment on any case before the courts, but we do, in this legislation, acknowledge the commitments under the Convention on Torture. There's no country in the world that has enshrined the article that you've asked for, because they all recognize that there is sometimes a need to be able to take appropriate action in the national interest of their country's security.
Many European countries have acknowledged Article 3 as an absolute, and then it is in line with European Human Rights Court. And we strongly believe that deportation should not act as a substitute for punishment. Terrorists should be, criminals should be prosecuted here. If you send them back, it will lead to more impunity. And Honorable Minister, today you are the Minister of Immigration and Citizenship and Immigration. Tomorrow somebody else will be. Please lay a foundation that in future you will be able to defend it.
I'm just going to keep going. You had something else you wanted to get in.
This is totally off the topics we've been talking about. I'm talking about proposed regulations that came out recently, and I'm talking about the comments by yourself in the department that you're opening up the door and letting people in the front end and closing, kicking out the criminals. With respect to blue-collar workers, I've read the regulations. I've been in part of consultations, and I've heard lots of talk about the best and the brightest and the best and the brightest. Now, I've heard the department say the best and the brightest means the higher the education, the more income they'll earn in the long run, even based on outdated studies. I take this as an affront to basic Canadian values and basic liberal values. I look at what Canada needs and has traditionally needed is hard-working, good, honest people. I want to understand how you're going to be able to explain to your constituents who have brothers and sisters overseas and they're blue-collar workers and skilled workers who don't necessarily have university degrees or 2 years of post-secondary education, but they do have all their family in Canada. They do have jobs waiting for them in Canada. They are fluent in English, but they can't come because their education isn't post-secondary education.
Well,
how
in
is
fact,
that
Robin's
possible?
absolutely wrong. First of all, what she's talking about are regulations, which are work in progress, which recognize the need for skilled trades, and we want to be able to bring those people. If someone has a validated job offer, they are facilitated to come to Canada, and we are expanding family class, and that's part of our discussions with the provinces on how to do that. The regulations are work in progress, and I'm looking forward to continued discussion. But what she has just said is a complete and gross misrepresentation. It's not in the legislation. And in fact, I heard her say the same thing on radio, which tells me that you can't believe everything that the lawyers are telling you about this bill.
I'd like to obviously to respond. I'm reading from the proposed regulations that appeared when they came out for C31.
I understand you're talking about regulations, but what I'm saying is the regulations are work in progress.
I'd like
Legally,
to finish my comments.
we cannot begin the consultation on
I'd like to finish my comments
till
because
after the bill is passed. Let's discuss the bill.
I'm talking about
We're
the future.
also discussing work in progress on regulations.
I'd like to talk about the future, and since it is a proposal, I'm concerned that it's shortchanging Canadians.
I know Robin would like us to approve all of her clients. I'm
Counterspin.
saying she just needs better clients.
You had a comment. Go ahead.
I wanted to say, okay, in the premise of keeping things down to earth, call a spade for a spade. I agree with the gentleman on the panel always saying this legislation is imbued with racist rhetoric. It has Eurocentric overtones. We're talking about permanent residents who will be renamed as foreign nationals. When you automatically rename a group or even calling them a special interest group or whatever have you as a foreign national, you further marginalize them in society. We're not talking about a bill that's going to better these people. We're talking about fragmenting families. We're talking about separating people's lives. We're talking about, the gentleman said, breaking up families. You are automatically marginalizing people's voices. You're automatically delegitimizing the fact that they...